Ms. Rachel Rubenstein was riding in her self-driving car, the newest model from Oliva Industries Incorporated. This model of the Oliva requires no input from the driver, save for the destination. Once in transit, passengers cannot control their vehicle. In order to avoid hitting a jaywalking pedestrian, Ms. Rubenstein's car swerved into oncoming traffic, T-boning a Mr. Shimon Shalom's car. Ms. Rubenstein rose from the wreckage and, seeing that Mr. Shalom had been injured, immediately called 911. Though Mr. Shalom survived, he was hospitalized for months. Mr. Shalom is suing Ms. Rubenstein for full damages, including the cost of his hospital stay, his lost wages, and damages to his car. While Ms. Rubenstein certainly does not want Mr. Shalom to face any more hardship than he already has, she doesn't feel responsible for having harmed Mr. Shalom, seeing as she had no control over the actions of her vehicle, and, frankly, would struggle to pay Mr. Shalom all that he is asking for. Ms. Rubenstein referred Mr. Shalom to Eli Levine, the CEO of Oliva Industries Incorporated, who said that the car was designed to minimize the risk of fatalities, and, as such, Oliva is not responsible for Mr. Shalom's damages. Throughout this case, this Beit Din will explain why Mr. Levine's argument is flawed, while bringing forward evidence to prove that Ms. Rubenstein should not be held responsible in any way, as she could not control her vehicle, and that Oliva Industries Incorporated is wholly liable, as it was, in essence, driving the vehicle at the time of the collision. While the Oliva was programmed to minimize damages, it failed to do so here, with Mr. Shalom nearly losing his life and facing massive debt in his survival. Damages that would have been minimized if the system had held to a lower speed, securing a larger stopping distance, potentially allowing for this accident to have been avoided.
Our first source, Bava Kama 22ab, contains a machloket over why a person is responsible for their fire. Rabbi Yochanan feels that they are responsible because they have direct agency over their fire. Reish Lakish disagrees, saying that it is because their fire is their property. Rava agrees with Rabbi Yochanan because the verse and Mishnah in question here are discussing the responsibility when the fire spreads, and the passive tone there suggests that this ruling applies even when the fire spreads on its own, when it is no longer in the possession or control of the lighter. This Gemara is based on Shmo 22:5, which states that the one who sets a fire should pay for the damage it causes. We agree with Rabbi Yochanan and Rava. We feel that a self-driving car is halachically similar to a flame, in that the user has direct agency over its creation, but not necessarily what happens to it after that point. In fact, because of the lack of human override capabilities in the car, no one had true control over it after its manufacture, similar to a flame. Even though Oliva was not in possession of the car when the crash occurred, it made and coded the car. It set the fire. Therefore, it is culpable for the damage that the car caused, even after it left its control. Baba Kama 2a4 explains that when something is in a category that typically causes damage, like a flame or a pit, it's the owner or generator's responsibility to prevent that damage from occurring. If they fail in prevention, it is then their responsibility to pay restitution for whatever damage occurs. We believe that a car can be considered to typically cause damage. Thousands of crashes occur per day worldwide, each of which usually results in death and/or serious damage to property. As already discussed, we feel that a self-driving car is comparable to a flame, meaning that the generator, not the owner, is responsible. Oliva Industries is the generator of the car and its code, and therefore should pay for the damages resulting from it. Defenders of Oliva might claim that their course of action was the best one, as it minimized damage. Regardless of whether this is true, it doesn't exempt them from guilt. Bava Kama 60b explains that one is not permitted to rescue oneself through the destruction of others' property, unless they are a king, but no one involved in this case is royalty. How much more is it forbidden, then, to save oneself through damage to another person? Oliva's decision to save the pedestrian or passenger through harm to another driver is therefore unacceptable. Those in favor of Oliva might also feel that there was no better option than what it chose to make its car do. Again, even if this is the case, Oliva must still pay. Bava Metzia 93b discusses 4 types of guardians to whom different halachot apply. One type is a paid guardian. We believe Oliva should be considered a paid guardian of the car. It received what was likely a hefty sum for the assurance that its programming would keep the car, its passengers, and others on the road safe. Bava Metzia 93b continues and states that if a paid guardian has done their best to guard their charge and fails, they must swear that the damage was caused by circumstances they could not control. If this is the case, they are not liable for the loss, but they still must pay for it. Therefore, it is Oliva's responsibility to pay for the damage, even if it could not have been avoided. However, the car should never have reached a point where damage could not have been avoided. The responsa of Rabbeinu Asher 1015 discusses a claim that one hurt by a person riding in a street is not owed restitution. because the street is a public place and the rider was permitted to travel there. Rabbeinu Asher rules that this claim is absurd, because a person is not even allowed to run in public so fast that they cannot stop if need be, let alone ride. He also notes that a person who causes damage to another using an animal is considered as if they damaged the person with their own body. Therefore, Aliva Industries was not allowed to program the Aliva in such a way that allowed it to get into situations where it could not avoid damage, and the damage caused by its cars is considered to be caused by Aliva Industries itself.
In an ordinary car, the driver would honk their horn as a form of communication. This conveys a message to stop. Bava Kama 3.5 says that about a beam carrier who crashes into the jug of a jug carrier and breaks the jug. The beam carrier is liable for the damage unless he tells the jug carrier to stop. If the beam owner stopped, he is liable. But if he said to the jug owner, stop, he is exempt. However, in this fully automatic Aliva, there is no way to honk or tell another person to stop. As Ms. Rubenstein's car left her unable to communicate with other people on the road, it was up to the car, and therefore the program to honk for her, which it failed to do. As far as how much Aliva owes, we believe we should follow Bava Kama 812. This text states that one who harms a fellow should pay them for the damages, suffering, medical expenses, lost wages, and embarrassment. This is what Aliva should pay: the cost of Mr. Shalom's hospital stay, the cost of the damage to both cars, the wages that Mr. Shalom lost while out of work, as well as an additional sum for the suffering caused. As for the fate of Aliva's self-driving cars, we believe they should be recalled. Shemot 21:29 states that if a bull known to be in habit of goring kills a person, the bull should be killed. It also says the owner should be stoned to death, but we think that paying the restitution discussed above is sufficient. Aliva's self-driving cars follow a set code. Considering an accident of the sort happened once, an Aliva car could be put in the same situation in the future, causing a similar accident. We think this constitutes a habit of damage. While a car cannot be killed, we feel that a recall would be an appropriate equivalent. While Aliva's cars are safe, they are not halakhically sound, and they should not be on the road. This Beit Din does not consider the Aliva to be safer until it is equipped with a manual override. All these texts prove that Ms. Rubenstein is not responsible, and that Aliva is liable for the damages caused by its vehicles. So it is responsible for Mr. Shalom's damages in their entirety.
Most car accidents are caused by the driver of the car. However, in this case, seeing as Ms. Rubenstein was a passenger in a car equipped with the Aliva system, and therefore had no control over her vehicle, she cannot be held responsible.
Time. Judges, you have 8 minutes to ask questions.
So if they were able to identify the person who walked in front of the car, how would that have changed the liability of the company that made the car? Would it change?
Well, there have been similar situations in the past in which a tree has fallen in front of a car and that car has had to swerve. We consider this pedestrian to be acting like the tree. It merely exposed a flaw, and that flaw could have been exposed by a tree just as easily. So to blame the pedestrian is ineffective. We should actually almost be thanking the pedestrian for exposing this flaw now.
So the pedestrian would not be liable at all, even if you could identify that pedestrian?
Correct.
Especially because this was the first accident of this kind. That if this had also happened with a tree and it was documented, then the exact same thing would have happened. But because this was the first accident of this kind, as Matan said, this does expose a flaw.
Okay. But as you said before, the car doesn't really demonstrate a pattern until it's happened more than once, so.
That isn't something we said, that's something the previous group said.
Yep.
What we said is that because the car follows a set code, it's not likable, which acts based on factors we don't know. We know what it will do. In this situation, again, it would do the exact same thing. So even though it hasn't actually happened again, we think that that constitutes a habit.
Furthermore, the code does represent a pattern.
The
Like,
code itself, right?
Just the fact that there is a code means that there is a pattern.
Yes, a bull would follow its instinct. This car's programming is its instinct.
I see. Do you have another question?
So let's go back for a second. I'm still not clear I understand this. So what you're saying is by definition, having created the car, there's liability?
Yes.
And there's nothing that could have intervened that would have avoided liability. So in other words, the pedestrian causing the accident by virtue of the fact that it causes the car to swerve, what was the alternative that should have been done by the company?
Well, again, we don't, yes, of course.
As we spoke about, we consider Aliva to be a paid guardian. A paid guardian is responsible regardless of whether or not, a paid guardian, if something happens that is beyond their control to whatever they are guarding, they are not considered liable, but they still must pay damages.
Actually,
Has they
actually, are you talking about the concept of shomer sachar aren't they avoiding liability in the case of onus, which would be an accident?
Would you say that this isn't an accident?
This isn't an accident?
The jaywalker did not necessarily know that Ms. Rubenstein's car was a self-driving car and that it could not go on instant.
No, but vis-à-vis Eliav's Industries, isn't this an accident?
Yes, but they
Yes.
are at fault for designing something that could get
But
into this
that,
situation.
I go back to the question I posed was, if they are a paid bailee, and it's unclear to me that an inventor would be a bailee, but let's take that as a given, that wouldn't they still be avoiding liability on the basis of the fact that this was an accident?
I'm not familiar with that text. In the
I-
text that we're discussing, it says that regardless of whether or not the circumstances are beyond their control, if they are beyond their control, they must swear that that's the case, and they still must pay, even if they are not considered
But
fully
Also,
liable.
Not in
also,
the case-
I would for sure agree with you that this is an accident. However, it is an accident that was predisposed. This was planned by Aliva, not for this to happen, but for in this situation, this would be the course of action. We also don't necessarily know the other people on the sidewalk, but say, for example, this jaywalking pedestrian was the only person on the sidewalk. The Aliva, we can assume, is programmed to stay on the road, but a human could notice that there are no others on the sidewalk and could swerve onto the sidewalk to avoid hurting anyone else.
It's the
Let me,
level of.
let me shift to another area. The notion of lost wages, what's the basis for that?
It discusses it in the text that we
But-
mentioned. It is one of the texts in the source sheet, if you have that with you.
Yeah, the source
So,
sheet, though, the payment of the 5 types of compensation are based upon human action directly, not indirectly. So what is the direct human action here?
The creation of the car and its code.
Creation of the car is a direct human action?
Through the our argument, we compare it to a fire, which is also uncontrollable, and
But a
the
fire would
damages
not-
caused by a fire is someone who set it. So, like inventing an object is like setting a fire.
Right, but the
That's a
problem is,
direct-
but are you saying then that if I set a fire, I'm responsible for 5 types of compensation as opposed to direct human action, as in striking someone?
Yeah, how do you
Yes.
distinguish?
The Gemara and the Mishnah seem to talk about striking someone, which is a direct human action, as opposed to the creation of a fire or anything else. So,
So one follow-up to that is, you proposed a total recall of the car. Are you proposing a total recall of the car so that it can be reprogrammed, or are you proposing that a car that it created to, in any way, is going to have a level of accident nature that is unacceptable?
As mentioned in our presentation, we believe that the car should be recalled until a manual override has been installed, and also until the riders of the vehicle are able to honk their horn to let others know of their presence and to let others know that they're coming and they should watch out.
let me ask just one other question. Are you taking the position as well that, based on the Gemara that talks about a king, that is talking about any use of private property to save oneself? Or is it that the problem there was that, in the case of David HaMelech, that what he did was he burned down the entire area, which was more than he needed?
I don't believe that the text that we have directly discusses that. However, we do think that in destroying essentially Mr. Shalom's livelihood, this is a pretty serious damage to physical
Yes.
property.
It's not only destroying his car, it's also injuring him. We don't know what his occupation is, but say his occupation is something that involves a lot of physicality, he likely will not be able to participate in that perhaps ever again.
So let me see if I understand. Is your position that the car should have been programmed to hit the pedestrian?
No.
Our position is that the car should have been programmed and designed in such a way that the human would be able to take over and would be able to come up with another exit strategy for this situation.
So let me take the following case. The car is going 15 miles an hour. Someone jumps out right in front of the car at a distance of 3 feet. They've done all the changes that you wanted. There's no way to stop. Who's responsible?
Well, I'm not sure 15 miles an hour is a
15,
distant.
he said.
15.
15 is,
Yeah.
I feel like if you hit the person.
The person,
you won't do
Time.
okay.
Okay, thank you
Thank
very
you.
much.
Thank you.
We'll now be having a 10-minute break. It's a 10-minute break, not a 5-minute break.